Hi there, I'm Savannah Mexto with Mannor Law Group, welcoming you to another webinar Wednesday with esteemed estate planning and elder law attorney, Bob Mannor. Most people are not aware of the many diverse options available for estate planning. Many people can make misguided decisions when it comes to wills, trusts, and estate plans. If you're considering making a plan to protect you and your family's future, where do you even begin? Today, you can cut through the confusion with attorney Bob Mannor. But before I pass the mic to Bob, I'd like to cover a few housekeeping details. First, note that even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. Also, if you have a general question during today's presentation, we encourage you to use the question box. We will save time to review questions during the webinar. If for some reason we don't get to your question, we'll contact you after the presentation. Also, today's presentation will be recorded and the replay will be sent out tomorrow so that you can share it with your family, your friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? Note that we are a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Our managing attorney, Bob Mannor, is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And lastly, my personal favorite reason, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. And without further ado, I'd like to welcome attorney Bob Mannor.
Hi, folks. This is always a good topic to cover, and we're going to get right into it. So one of the things that people often ask about is, well, what's the difference between a will and a trust? And so we're going to talk about that. And for years now, I've been using these visuals to kind of explain the differences. And so I know that I'm a visual learner, so I tend to be a visual teacher. And we have these visuals to explain a will versus a trust. So over here we have option A, which is the funnel, and I like to call the will a funnel. Why is the will a funnel? Well, the will is a funnel because it's a catch-all. If you pass away and there's an asset only in your name and it doesn't have any other mechanism of transfer, then the will catch it and it'll funnel it down to where you wanted it to go, at least according to what your will says. What people don't like about the funnel is that middle part of the funnel. The middle part of the funnel where the assets have to go through this probate process. And a lot of people think that you don't have to go through probate with a will, but what that means is that they didn't need the will because the will has no legal effect without going through the probate process. A probate process that takes a minimum of 5 months in Michigan to go through what's called the decedent's estate process. What also people don't realize is that if you don't write a will and you don't have any other legal documents in place of your will, then the state of Michigan has written a will for you, and they call that intestate succession. So if you have a will or don't have a will, it likely means that things are going to go through probate. And people don't like that idea of having the court involved when they've got perfectly capable family members who could take care of it without having the government or court interference there. So what things don't go through the funnel, what things don't go through the will, don't go through probate. And that's going to be anything that has a beneficiary designation on it upon your death, anything that has payable on death, transfer on death, anything that is jointly held with somebody else that either of them can access it fully, and of course trusts. Now we're going to talk about why sometimes just using beneficiary designations and certainly joint owners is not always the best idea. However, we're also going to talk about trusts and what the difference is. So if a will can be a funnel, then a trust can be a little red wagon. What do I mean by that? Well, the little red wagon is my image or my visual for explaining a trust. So unlike a funnel, it's not a catch-all. It doesn't catch whatever needs to be caught. So if you die and you own a house, it's not necessarily going to catch your house. So how do we make sure the trust is going to work properly for the house? And the answer is we have to retitle the house. We have to have a new deed that transfers the house into the wagon or the trust. Now, some folks would say, well, that sounds like a bad idea. Now I'm giving up my control of the house. Absolutely not. That's my other reason why I call it a wagon, is that you're in charge of it. So I kind of use the example of when you were a kid, if you had a little red wagon, who was in charge of it? Well, you were. Who got to decide what to put into it and play with, and to pull around? You did. Who got to decide what to take out and play with? You did. If you got tired of pulling it around and you were playing with your friends, who got to decide who was going to pull it around next? You did. So you are in complete control. In fact, the law treats it as if you have a revocable trust. The law treats it as if it doesn't exist as long as you're alive and healthy. And you barely even notice that you have a trust, which is one of the reasons why sometimes trusts don't work, because people forget how they work. And they only work for those assets that we retitle to the trust. So we'd retitle your bank account, we'd retitle your investment account, we'd retitle that annuity, we'd list the trust as beneficiary of life insurance. Many people are told that you do not put retirement accounts or IRAs in the trust, and that's partly true. You don't do it during your lifetime, but if the trust is written correctly or properly to have that language in there, then in some cases we can list the trust as a beneficiary under an IRA. Well, why would we want to? Why do we want to have everything? If we can have beneficiary designations or joint owners or whatever else, why would we want to have it in the trust? And I think this is the biggest reason for the having it in the trust, is because it's not just to cover you upon death. A lot of people think of the trust as just probate avoidance on death. Well, the people that think of it that way often don't avoid probate because they didn't end up putting all their assets in, or even if they did, over the years, they buy a new condo and now the condo's not in the trust, or they switch bank accounts and now the bank accounts are not in the trust, or whatever else that happens through the years. And so yes, that's a very good reason for a trust, is the probate avoidance. But the second reason, and why I like people to understand how the trust works, is because there's a pretty good chance you're going to get sick at some point in your life. There are the lucky few that live a long, healthy life and never really get sick and then die peacefully in their sleep. That's, possible, right? It's pretty rare. So most people are going to have some period of time before their death that they're going to need some assistance, that they're going to need some help. And it's actually much simpler for your family or whoever it is that you would want help from to be able to organize it, keep track of it, be able to pay your bills, be able to help you with everything, if everything is nicely organized according to one set of rules, which is the trust. So I like to call the trust a wagon to remind people, number one, you're in charge. Number two, we got to put the stuff in the wagon. We got to retitle things to the wagon. But what is it really? When we really boil it down, what is a trust? And the answer is it's a contract. It's a contract typically between you and your family, or you and the people that you want to include in your trust. But most people, it's you and their family. And the trust then empowers or authorizes your family to be able to step in and do what needs to be done. And you can write the terms of the contract in so many ways and cover so many contingencies. So a lot of people will, for example, they'll want to do deeds or ladybird deeds or quitclaim deeds or whatever. The problem with all of those things is we don't know when you're going to die. And I laugh when I say that because it's just something that you don't, obviously we don't know that, but most people don't kind of think that through. And so we have this one piece of paper that has no contingencies, has no view of the future, has no way of saying, well, what if this happens or what if that happens? And so the thing is, the trust can do all of that. And so I don't like using just beneficiary designations or using a ladybird deed or a quitclaim deed in most cases, because we don't know that the person that you're appointing or the person that you want to have the house, or particularly if it's multiple people, we don't know that they're going to be alive when you're gone. Now we might think they are, but we don't know. And so the trust can contemplate that. The trust can say, well, what if? What if somebody dies in the wrong order? What if they are incapacitated? What if they're going through a divorce? What if they have in the middle of a lawsuit and they might be subject to lawsuits? What if, and this is one of the things that a lot of people do, they'll say, okay, well, I'm transferring it to all my kids and I've got 3 kids. All right, well, what if the kids don't get along? And you say, oh, but my kids do get along. Great. Will they get along forever? And will their spouses affect whether or not they get along? And what's the world look like in 30 years or 20 years or 10 years or 6 months from now? You know, this last year or so, we've seen how many things can change so dramatically, really quickly, without a whole lot of warning. And so when we're trying to plan for the rest of our life, whether it be 6 months or 10 years or 20 years or 50 years, we can't just imagine everything's going to be exactly the same as it is now. And so beneficiary designations, deeds, ladybird deeds, joint owners, all of those things, well, they create some other problems too. This isn't the only problem, but the biggest thing is they don't contemplate the future. They just assume everything's going to stay exactly the way it is now, and I can guarantee it won't. Okay, and so that's the idea. The trust can have contingencies and backups and deal with all the different things. It can have a contract. It is a contract that will go through all of the different options to make sure that your wishes are actually carried out, regardless of the things that happen in the future. And of course, it's amendable. One of the things that people will say in response to this line of thought is, oh, well, yes, but if any of those things happen, then I'll just go and change my documents. I'll go and change it. When was the last time you saw your lawyer? Do you see your lawyer every year? I mean, my clients, a lot of them, they do. A lot of my clients choose to, because we have sort of this ongoing client meeting that we do as sort of a joint client meeting, a big client meeting, and we put it on videotape. And so they at least see me on video, if not in person, once a year, a lot of times for our clients. But that's not the norm in the industry, right? When was the last time you actually went to your lawyer? And typically, once people realize, oh yeah, I probably need to update those things, it might be a year or 5 years or 20 years after that they just actually go to their lawyer. And then the other thing is, a lot of times people don't, that's not the first thing on their mind when something changed, when there's a death in the family, when there's an illness, when there's a divorce, when there's a new birth, you know, when there's an economic change, when there's a global pandemic, you know, that's not the first thing on their mind to say, oh, well, I better go call my lawyer because there's another change in the world, another change in my life, and I need to update my documents. So why not have a document that contemplates these things, that says, okay, well, we have a contingency if these types of things happen. We have built in that there might be additional children born or additional grandchildren born. We have it built in that somebody might die before you. We have it built in that somebody might get divorced. We have it built in that somebody might have financial difficulties. Because if you don't have something that goes through all of these contingencies, then you got to be talking to your lawyer a heck of a lot, and it's going to cost you a heck of a lot more than just setting it up right the first time. So, all right, so that's the idea. The next thing with trust, as I mentioned, it can be it is a contract. And so the idea of the contract is you can actually lay out your terms and provide for better options for your family. So provide for better tax savings for your family. The tax law as it relates to retirement accounts has changed dramatically in the last couple of years. So January 1st, 2020, the Secure Act took effect, and it drastically changed how your retirement accounts are going to be taxed upon your death, whether it goes to your children. And we then, for most of our clients, we updated their documents to comply with these new rules. What we feel is by having the rules incorporated in your trust, we're able to lay them out in such a way with contingencies to make it much more likely that we're going to minimize taxes. You know, ultimately, there's going to be some decision making on the part of your kids to minimize taxes, but it's going to be much more feasible and they're much more likely that they're going to get the proper advice if those IRAs go through the trust that has the Secure Act language in it that we now put in our trusts. Of course, in dealing with young children, well, young children can't be in charge of they can't own a house, they can't be in charge of large sums of money. If you're under 18 and you get receive this money, the court has to, and you don't have a legal guardian. If you have a legal guardian, a parent, then they can be in charge of it. But if they don't have a legal guardian, the court is going to appoint somebody called a conservator for them until they turn 18. And so there's two problems with that. One is that now we get the court involved. And the second thing is when they turn 18, they get all the money. So if you have a $300,000 IRA and you have one child, that 18-year-old, when they turn 18, they might be 12 now, but if you die and they turn 18, they're going to get the $300,000 to do whatever they want with. Now, how many 18-year-olds have significant or enough life experience and knowledge of how to handle $300,000, how to manage $300,000, and how many 18-year-olds would prefer to go buy a sports car rather than use that money for college? Now, some of them would, no question, but a whole heck of a lot of them would maybe not know how to manage that kind of money. So that's why it's better not to have it go through the court system, have it better where it's going to be managed for them until they're a little bit older and have a little bit more life experience. And then we have these things called lifetime protector trusts for the children. So I'm going to jump into that for a couple minutes. So imagine we have 3 kids, and we've got Susie, Roger, and Danny. Now we've got also this old guy over here lurking in the corner. Who's the old guy? Well, that's Uncle Sam. Uncle Sam wants your money too, right? Uncle Sam wants taxes. And so one of the things we want to do is not adopt Uncle Sam as our 4th child, where Uncle Sam gets more money than the kids do, right? We want to have the kids get more money than Uncle Sam when it comes to taxes. And there's definitely ways to plan for that. But the idea of Susie, Roger, and Danny, they're all in different circumstances. So Susie's wonderful child, generally makes good decisions. We really love her. She calls us every day. We just don't know why she married that idiot son-in-law of ours. And wouldn't it be great if we could get the money to Susie and not let our idiot son-in-law get his hands on it? Or worse, if they got divorced, that he'd get half of it, So wouldn't it be great if we can make sure that it's only going to go to Susie and the idiot son-in-law doesn't get it? Roger's in a different situation. Roger was doing quite well until he lost his job or his business failed or whatever it is. And now he has some debt. So what's going to happen if Roger has debt when he inherits this money? Well, they're going to be there grabbing that money as soon as you die, as soon as he gets his inheritance. His creditors, the people he owes money to, are going to grab that money right away. Wouldn't it be great if we could give Roger a fresh start and be able to get him his inheritance without having it eaten up by his old debt, by his old business debt, or because he lost his job, or because his house was foreclosed, or whatever it is? Wouldn't it be great that we could get the money to Roger and it's not just going to pay for old debt? And Danny's a little different situation. Danny's on supplemental security income, SSI, meaning that he's a special needs or has some reason why he can't work. And so he has medical benefits and he has disability benefits. And what happens then, and maybe even Medicaid, and what happens then if we leave him an inheritance directly? Well, he's going to lose his medical benefits, he's going to lose his disability benefits, and he's going to lose his Medicaid. And so is there a way that we could get the money to Susie, Roger, and Danny and not have these negative effects? And the answer is, of course. I probably wouldn't have brought it up if there wasn't a way. And the answer is these lifetime protector trusts. So Susie manages her share. She can buy a house with it. It's protected from divorce. She can invest it however she wants. She can take the money out and spend it. Roger he has his lifetime protector trust. He could even start a new business or, but basically as long as it's under that umbrella or under this lifetime protector trust, it's not going to be subject to his debts, okay? Danny's a little bit different in that Danny can't be in charge. So Roger's in charge of his, Susie's in charge of hers. Danny's not allowed to be in charge of his. That's the rules under the, even if he's capable, even if he's able to be in charge, the rules will say under the disability rules and Medicaid rules and Social Security rules that he's not allowed to be in charge. So we put Susie or Roger or somebody else, a third party, in charge of it they still make sure that Danny has a house, that he has a cell phone, that he has all these other things that are going to make his life better, right? And so he still can get his inheritance. We just can't give it to him directly, and he can't be directly in charge of it. We got to put somebody else in charge of it. All right, so this is a really good option. This is how I'm saying, like, that trust can come up with all of these different contingencies and say, well, what if? Why don't we, have some extra benefits in there? Why don't we have some extra protections in there? And that's the things that a trust can do. So I've got a couple of other questions, and it goes beyond just wills and trusts. And that is, who would pay your bills for you if you get sick, if you get too sick to be able to get to the bank? Who would make medical decisions for you, including whether or not to be on life support if you can't do it yourself because you're in a coma or you have Alzheimer's or something like that? And so one of the answers I get is, well, I'm just going to put my kids' names on the accounts. And so if you see my slide, you may get my answer there. Should you put your kids' names on your accounts? No, don't put your kids' names on your accounts. And I can say this a million times, and I know you're still going to do it, or a lot of people are going to do it. And so if you have them on one account, a small account, that's one thing. But to put their name on the house or put their name on the investment account, this is such a bad idea. Just don't do it. There's so many reasons why that's a bad idea. And so it could be, some of the times people say, well, my kids are trustworthy. Yeah, okay, I assume they're trustworthy. I assume you wouldn't put their name on it if they weren't trustworthy, right? But does bad things happen to good people? Do good people that are trustworthy ever get sick and have medical bills? Because if their name's on it, they can come and take your money because of their problems, because of the kids' problems. The kid's not taking it, the people they owe money to can take it. So what if they got divorced? That money can be tied up in a divorce. What if they didn't pay their credit card bill? What if their house got foreclosed? Your money can go to pay their bills, okay? What if they got sick? What if their spouse got sick? When it comes to things like nursing home, you could be responsible for your son-in-law or daughter-in-law's expenses because if your daughter's name is on your account, then that's counted as her asset when it comes to nursing home and things like that. And your money's exposed to not only her medical needs, but her spouse's medical needs, right? And so it's just such a bad idea. Don't put your kids' names on accounts. This is just not something to do. And there's so many better answers. I know people have done it for years. They've done it for generations. Trust me, this is one of the worst things that you can do. And there's better answers, much, much better answers. And then the last thing I want to cover is that it's important to understand that there's legal processes and documents that occur during lifetime, and there's legal processes and documents that occur after death, and there's very little overlap. So your dual powers of attorney don't work after death. Your healthcare power of attorney doesn't work after death. Guardianship or conservatorship has no power after death. Okay, after death, during lifetime, your will has no effect. POD, beneficiary designations, have no effect. Any kind of provision in your will doesn't have any effect until you're deceased and the court puts it into effect. You see, there is one overlap though, and that is those trusts. Those trusts are designed to be able to help you manage things both for yourself, and if you ever get too sick to manage it, to have somebody else help you, both during lifetime and after death. So that's sort of the one thing, or one of the few things, that encompasses both illness and death, and and when you're healthy. So something to give some thought to on that too. So do we have any questions? And if you do, you can put them in the question box. If you have questions that you'd like to talk to us one-on-one, Savannah's going to come on and she is going to give you instructions on how to get those questions answered, how to come in and see us, how to see whether or not we're going to be a good fit for you, and whether we should do your legal documents for you. And consider getting prepared. Consider getting things done now, as opposed to, well, yeah, I'll do that later, I'll do that someday. So Savannah, if you want to kind of give some instructions as to what their next step is.
Yeah, thanks, Bob, and thanks everyone for joining us today. As Bob mentioned, we do have actually 2 easy ways for you to get in touch with our team. If you want to talk about your legal planning, maybe you already have a plan and you want us to take a look at the planning that you already have, or maybe you don't have one yet, and so you want to make sure that that's covered. There's a way that you can contact our team. You can, of course, call 1-800-990-6030. Or if you look in the chat box, I have put a link. The link will take you to a calendar. On that calendar, you can choose a day and a time when a member of our team will call you. There's no risk, there's no obligation. This call should take about maybe 10-15 minutes, totally free, and we'll be able to tell from the end of that call, you as well, if we're the right law firm for you. So again, that phone number is 1-800-990-6030, or you can click the link that I've put in the chat and choose the day and time that we can call you. I've also got an email that's going to be coming out to you probably in about 20 minutes, and it will have that same link and our phone number there for you as well, and you can always just reply to that email. So again, thank you for joining us. It's always so great to have you, and we will see you again next week.